The Criminal Code Amendment Bill was a key topic of discussion during the sitting of the House on Tuesday, March 11th. Attorney General Leslie Mondesi addressed the Speaker and the members of the House outlining the bill's provisions. He explained that it introduces the concept of a judge-alone trial, where a judge independently determines questions of fact and law, ultimately deciding the guilt or innocence of an accused person. While this concept is not new and is already practiced in various countries, including Antigua and Barbuda, Jamaica, St. Kitts and Nevis, the Cayman Islands, and Belize, Mondesi emphasized the need for St. Lucia to embrace this approach, despite the traditional reliance on jury trials that have been in practice for over 800 years.
Why do you want a judge-alone trials? Well, judge-alone trials would be suited for certain types of cases. You may have a high-profile case, a serious case, a murder trial, a long and complex case which involves technical evidence. You may have a case which engenders pre-trial publicity. Graphic evidence may be led in a trial. You may have allegations of intimidation or threat to jurors or bias. So you may want to have a judge-alone trials.
He acknowledged the presence of skeptics, but asserted that over time, the benefits of this change, particularly in reducing the backlog of cases, would become evident.
Now, I want to put on the record, Mr. Speaker, that the Criminal Division of the High Court continues to struggle with a significant backlog of criminal cases, and they are unable to dispose of those criminal cases in a timely manner. On average, cases get stuck in the system and may take a couple of years before actually coming to trial. The statistics that have been conducted suggest that countries that have introduced judge-alone trials have seen a significant reduction in those cases.
Local Government and Housing Minister Honorable Richard Frederick expressed his support for the Criminal Code Amendment, but pointed out an aspect he felt was missing. Speaking from a defense lawyer's perspective, he noted that any party involved in criminal proceedings would favor a swift resolution, provided that a balance is maintained.
You call the prosecutor, defense counsel goes with the magistrate, and you say, look, it was this, it was that. What is your likely sentence? Without necessarily clouding the mind of the arbiter. And then you could say, okay, my client, I wouldn't give, if we go down that road, he'll get 3 months rather than a year. You go back to your client, and that can be done and arranged.
He urged that this gap be addressed in the amendment to facilitate a more expedited resolution of criminal matters within the jurisdiction. Opposition leader Alan Chasney also expressed his support for the bill, noting that it was an initiative his previous government had been working on.
This is a very important step for St. Lucia. We've seen the backlog of cases, and while there may be great expectations that a judge-only trial is going to help expedite those, I think it will, but I don't think that that's the total panacea that we're looking for. There are some other issues that we have to resolve.
He acknowledged the potential challenges related to jury trials. The Criminal Code Amendment Bill, which amends the Criminal Code Cap 3.01, successfully progressed through its committee stage without amendments and was read a third time before being passed. It is now officially the Criminal Code Amendment Act 2025. Kayla Edwin, MBC Prime.